From my perspective, digital rights are human rights which are exercised within a digital space. So if you conceive of it that way, then definitely there's a close relationship between digital rights and human rights.
Hello, welcome to another edition of the Africa Digital Rights Podcast, where we discuss everything data protection and privacy, intellectual property rights, child online protection, cybersecurity, and data governance in Africa. My name is Teki Akwete, and I'm your host for today. We are lucky today to have been joined by a very good friend of mine and a professor that will introduce himself shortly. And I really wanted to have this conversation around digital rights broadly in Africa. Professor Frimpong, kindly introduce yourself to our audience and welcome to the ADRH podcast show.
Thank you very much, Teki. My name is Richard Oppong. I'm a professor of law at California Western School of Law in San Diego, and I'm also a member of the Ghana Bar and a fellow of the Ghana Academy of Arts and Sciences.
Richard is very, very knowledgeable. Can I call you Richard, or I have
Absolutely.
to say? is very, very knowledgeable on a broad number of subjects. But I really brought you here because more recently you did some work around digitalization in Ghana and around legal systems and all of that. And I thought that, I wanted to have this conversation with you on digitization and digital rights in particular in Africa. Now, a number of people tend to think, and I engage with a lot of people across the world, and they tend to think, look, Africa has bigger issues to contend with. We have challenges around healthcare, around education, and all of that. So why are you even out there talking about digital rights and all of that? Do you think any of these issues are really important at this stage of our development as a continent?
Thank you very much. Thank you for the opportunity to join you. I think that that's a very important question, and I think for a proper appreciation of the question, we have to understand what constitutes digital rights. And from my perspective, digital rights are human rights which are exercised within a digital space. So if you conceive of it that way, then definitely there's a close relationship between digital rights and human rights. And it therefore harkens back to an issue which has been debated for some time, whether or not Africa should develop first before it pays attention to human rights, or it should pay attention to human rights while it develops. So this question is very similar to that issue. And from my perspective, definitely that is something that we have to do immediately. We have to pay attention to digital rights because at present, we live our lives both online and offline. And there's no way that we can go back to the decades before where everything was done in an analog way or in a face-to-face fashion. So to the extent that we think that digital rights are essential to economic development, and I don't think there's any debate about that, it's crucial to national development. We transact online. Electronic commerce is a significant feature of a lot of the things that we do. The financial sector is also heavily digitalized. So there are so many aspects of our life now that is led online or we live online. So it's not something that we can ignore.
I really love the fact that you bring in the fundamental rights angle. A lot of our countries in Africa have not been, noted for being great guarantors of these rights. And so to that extent, do you think that we are even ready to deal with digital rights? Because I don't think we're doing a very good job when it comes to fundamental rights. So where do we place it?
Yeah, that's an important question. I think the starting point will be to appreciate that digital rights are actually human rights. So, as I indicated earlier, there is a very close relationship between the two. So, most of the rights that we characterize as digital rights already exist in the offline world. So, freedom of expression, privacy, um, the right to data, right to information, and things like that. They are all rights which are already, at least from the Ghanaian perspective, codified in the constitution. So the real question is, how do we translate those rights and enable them to be practiced within the online world? And I think there's already a lot of things which exist to enable us to practice digital rights meaningfully, at least in the Ghanaian context. There are a number of government institutions that are already dedicated to human rights, who can also add digital rights to their portfolio and make it a central part of their work. There are a number of non-governmental organizations dedicated to human rights who now have to pay a little more attention to digital rights because, as I said, there's a close affinity between that and human rights. There are a number of advocacy organizations. So we already have the infrastructure if you look at it from a human rights perspective. Of course, it's also different because it raises its own issues when you are practicing human rights online. But I think we have the infrastructure to make a meaningful impact.
Having said that, I mean, if you look across Africa, if you look at Ghana in particular, we're more than a decade into a lot of these enabling legislative frameworks but we're not seeing, the necessary transformation significantly. What do you think is really challenging enforcement of digital rights on the continent generally, but in particular in countries like Ghana?
Yeah, I think the infrastructure is certainly a problem. The number of people exercising their rights in the digital space is quite low compared to other countries in the world. So there's definitely the need to invest heavily in infrastructure to make digital facilities accessible to a greater number of people. I think we definitely need more laws
We need more
more
laws.
laws to regulate the space. It may surprise you that our laws do not cover all the issues that can arise in the digital context. So there's need for legislation.
But here's the situation, even with the ones you have, we're not even enforcing. So do we really need more laws?
No, I think having proper a regulatory regime is important because if people are going to enforce their rights, there has to be a foundation for it. And if the courts are going to be used as instruments for the enforcement, because when you talk about rights, you are talking about enforcement, and
Yes,
ultimately
exactly.
it will land in the courts. And if there's no proper framework for the courts to adjudicate some of these issues, then there cannot be any proper enforcement. So we should not discount the importance of having a sound body of law to regulate some of the issues that come up in the digital space.
Recently, I had an opportunity to speak at the European Data Protection Supervisors Conference where the focus was on enforcement. And it was quite clear they were facing some challenges, but nothing compared to what you see across the continent, especially when you're looking at countries that even have data protection laws. And Ghana is about 10 years in since we passed our laws in 2012. Do you think that the approach we're taking to these digital rights issues are appropriate? And if not, what should we be looking at, when it comes to these laws? Invariably, sometimes it looks as if, we are copying. And my challenge is that we are copying without the resources, without the capacity, without the the background sometimes that informs the countries that we're copying from. So, should we really, as a continent, be thinking about digital rights issues from a different perspective? You know, especially when we know that it is still an important thing we need to address. But without enforcement, then what's the essence?
Yeah, I think that's an important question. There's certainly nothing wrong with borrowing from other sources, and it's actually helpful that others are well advanced so that we don't have to develop things afresh on our own. But it's equally important that when we borrow from sources, we study carefully the content of the various instruments or principles that we are adopting. I think one of the problems that we have as a country is that when we enact laws, we don't precede it with some comprehensive discussion and study to know whether those principles that we are going to ultimately enshrine in law will be suitable for the community or for the society. So, in my opinion, before we adopt any law from any source, I think we have to start with a comprehensive study to ensure that it's suitable to our local needs. We have to make sure that our laws reflect our values because societies have different values. So recently I was reading about an European set of principles on digital rights and certain values there. And you see that is heavily influenced by the individualistic attitudes which exist in the West. That may not necessarily be the case in Ghana or in Africa, where there's a lot of emphasis on community. So, again, if you go back to the human rights example, yes, we have the International Human Rights Instrument, but if you look at the African Convention on Human and People's Rights, you see that there are some adaptations to fit the African context, and there's nothing wrong for us to do something similar when it comes to the digital content so that it reflects African values and Ghanaian values.
Let me touch on something that really bothers me, especially about a lot of these laws that we continue to see around the sector, and that's enforcement of these laws. I know you made reference to the fact that when it comes to digital rights and fundamental rights, it's closely linked with the enforcement of those rights. Why do you think we are really failing? And of course, I know this is not just in the sector of digital rights, which is fairly new, but why do you think we're failing on this enforcement issue?
I think that has always been a significant problem in our society, and it's not only limited to the digital context. It may be that it's a question of how we define enforcement, and maybe we understand enforcement in a different way. That we see enforcement not only as enforcement through state institutions, but enforcement through moral avenues, through pressure and things like that, which work to ensure that people comply. Of course, that is not going to necessarily work in the digital context. There should be a lot of state intervention if things are going to be done right. But at the end of the day, I think it's a question of how do we understand enforcement and whether we are looking only to the state as the institution responsible for enforcement, or there can be other mechanisms through which we can ensure adherence to some of these principles and laws without the need for the state to be directly
involved in it. I mean, when you look, and staying on that subject, when you look at a number of the laws, both around cybersecurity, around child online protection, also data protection, I keep seeing a trend until maybe GDPR. A lot of our laws have criminal sanctions attached to them. And usually in these spaces, the criminal sanction becomes like a last resort. And even engaging the processes for criminal sanctioning, I have been there before setting up the Data Protection Commission, where we were trying to make sure that organizations comply with their requirement to register, had significant challenges around, engaging the processes and all of that. Do you think we could be thinking, about these enforcement mechanisms that we continue to put in laws in a totally different way? And I'm asking this because you are coming from academia, and, should we start conceiving these issues differently?
I think in general, criminal sanctions has not been very effective when you are dealing with corporations, and we are looking at an
Yeah.
area which is heavily dominated by companies. So we should strengthen the civil mechanisms for enforcement. So if you look at the West, for example, a number of laws are enforced by individuals through the civil law process rather than relying only on the state, because the state definitely has limited resources, and especially in Ghana or in other African countries, it's very likely the resources will be devoted to other things. But if individuals are empowered to litigate to enforce some of these rights, I think that will be a better way to go rather than relying solely on the state, because ultimately it's individuals who are affected by some of these issues. So either litigating individually or through class action to enforce some of these rights, I think would be a better way to go than relying on criminal law.
Somebody in the regulatory space recently reached out to me and said that as the head of a civil society organization, we need you guys to be up and doing, because sometimes even as regulators, our hands are tired. And so, civil society can push that, in terms of that. I'm raising this because you brought in class actions and all of that. Do you think Africa is ready for that?
I don't see why we are not ready for that, because we litigate all the time.
At a huge cost to the people that engage in these. And for me, as a not-for-profit organization that is really going out there to raise funding, it really comes at a huge cost. Not just time, but we know that the experts that have to be involved in it and all. And so usually when you don't have that much high income, in fact, recently, when I was at the European Data Protection Supervisor, we had the opportunity to meet one of the key litigators of a lot of the issues, Shrimps, too. He was on the panel and he was talking about even the costs and the challenges around bringing litigation. And I'm just thinking, looking at the hundreds of thousands of euros that they will spend in litigating, I don't see any civil society organization really there. So do you think we are really the people that can really help push this, and how do we go around that?
I think we shouldn't only be looking at the cost, we should also be looking at the benefit, because this is a very underdeveloped area of the law.
Yeah.
So if the law is going to develop, it's going to develop either through legislation, where you may not get a lot of attention, or through the judicial process. And I think the ability of individuals to take on some of these cases and pursue them through the court system, even if it's at a cost, will ultimately be beneficial to individuals, because that is how human rights grow. And in the Ghana legal system, there is definitely opportunity for the law to develop, because the Constitution recognizes that it's not every right which is listed in the Constitution, and the courts can develop the law to fit societal needs. So we shouldn't discount the importance of litigation.
I love that, Richard. Thank you very much for joining us. All too soon, we've come to the end of another segment, and I look forward to having you join us on another Digital Rights Africa podcast, and have a good evening.